So as part of our Blackadders Talk Tech season, I'm today joined by my colleague Beth Buchanan as we aim to bring you an interesting legal tech development, the Friday 2-minute takeaway, which will get your weekend off to a flyer. So Beth, I mentioned last week that the UK government intends to turn the nation into an artificial intelligence powerhouse. And some recent developments have caught your attention on that front.
Yes, well, there was an interesting case recently at the UK Court of Appeal where it was ruled that artificial intelligence can't be named as the inventor in a patent application. And funnily enough, the Intellectual Property Office launched a consultation on this subject last Friday. So the case at the UK Court of Appeal related to 2 patent applications submitted to the UK Intellectual Property Office by a Dr. Stephen Thaler. And both of these applications listed the inventor as Dabis, which was an AI machine for the purpose of inventing. And the UK IPO had refused to process either application as they failed to comply with the requirements to list an inventor, as the current legislation requires an inventor to be a person. So in this case, the court was split 2-1, and it wasn't totally clear-cut.
So the argument put forward by Dr. Thaler seems to be that the actual innovation required to register a patent is coming from the AI itself as opposed to a human.
Yeah.
It's interesting it was a split decision. Do we know whether the point's been tested outside of the UK?
Yes, well, Dr. Thaler, in fact, has been sort of arguing this as a test case across several jurisdictions, and the patent applications were allowed with Dabis listed as the inventor in both Australia and South Africa, but were rejected by the European Patent Office and the US court, like in the UK.
Okay, so a bit of a mixed picture globally. I suppose that begs the question, Beth, where does the UK go from here?
Yeah, well, it's possible that this case will be appealed to the UK Supreme Court. And as I mentioned, the IPO did in fact publish a consultation last Friday on making changes to patent and copyright law to accommodate AI. And it's clear that the government do recognise that patents and copyright must provide the right incentives to AI development, you know, to promote human creativity and innovation. And the new consultation proposes 3 possible options in relation to patents. 1, allowing the application to name the AI as the inventor, as Dr. Thaler was pushing for. 2, expanding the definition of inventor to include humans responsible for the AI system. Or 3, creating a new type of right to protect AI inventions. Now, the paper doesn't propose that AI itself should be capable of owning any patent rights, but it is definitely a step in the right direction. The consultation closes on the 7th of January next year, so watch this space, I would say.
Yep, absolutely, Beth. And this option of creating a brand new right for AI inventions is interesting. And I suppose the concern might be that by adding another type of intellectual property into the mix, into an already complex system, then that might be a challenge, and it would need to fit in internationally. But it's certainly clear that there are challenges ahead for the lawmakers in striking the right balance in relation to intellectual property and artificial intelligence.
Yeah, definitely. Well, next they'll be saying that AI can replace lawyers.
Well, they'll be coming for the younger ones first, I'm sure. Well, on that note, we'll wrap things up. Thanks very much, Beth. Thank you for watching. We'll see you next time. Bye-bye.